Corporate Administration. Chapter 2. Formation of a Company. Introduction. Modern-day business requires large amount of money due to increasing competition and fast-changing technological environment. The element of risk is increasing. As a result, the company form of organization is being preferred by more and more business firms. Formation of a company is the term for the process of incorporation of a business. It is also referred to as company registration. Formation of a company is a complex activity involving completion of a lot of legal formalities and procedures. Stages in formation of company. The steps which are required from the time of business idea originates to the time a company is legally ready to commence business are referred to as stages in the formation of company. To fully understand the process, the formalities can divide into 4 distinct stages. They are: 1. Promotion. 2. Incorporation. 3. Capital subscription. 4. Commencement of business. It may be noted that for private limited company only first 2 stages, i.e. promotion and incorporation, are appropriate. Private company can start its business immediately after obtaining the certificate of incorporation. On the other hand, a public company goes through the capital subscription and then receives the certificate of business commencement. Therefore, a public company undergoes all the 4 stages. Promotion of a company. Promotion is the discovery of business opportunity and organization of funds, property, and skills and ability to run the business for the purpose of making profits, earning profits. It starts with conceiving an idea of business or discovers an opportunity for doing a business, assess its feasibility, and then take the necessary steps to launch the business unit. Promotion is always made through the promoters. The promoters are persons those who take the steps and associate risks for promoting and proceed to form a company. Roles and functions of promoters. 1. Discovering the idea for establishing a company. 2. Make detailed investigation about the demand for the product, availability of power, labor, raw material, etc. 3. Find out suitable person who are willing to act as first directors of the company and are ready to sign on the Memorandum of Association. 4. Selecting of bank, legal advisor, auditors and underwriters for the company. Corporate administration. 5. To prepare essential documents of the company. 6. To prepare the draft of Memorandum of Association, Articles of Association, Prospectus of the company. 7. To submit all the documents required for incorporation with the registrar. 8. To meet all the preliminary expenses for floating of a company. 9. To make contracts with vendor, underwriters and managing directors of the. 10. To raise the required finance and get the company going. Rights of promoters. 1. Right to receive preliminary expenses. 2. Right to receive remuneration for their services. 3. Right to receive the proportionate money from co-promoters. 1. To disclose the liability and pay the secret profits if promoters have earned. Liability of the promoters' olage. Company. 2. Liability is up to the completion of contracts. 3. Liability on statutory mistakes or fraud in the prospectus. 4. Property becomes liable for payment even after his death. Types of promoters. The task of business promotion may be carried out by an individual, a firm, a body corporate, or a banker. Based on the nature of their operation, the promoters can be classified into a. Professional promoters. These promoters are whole-time profession or occupation. Specialists in promoting new business ventures. They initiate all the steps in establishing new enterprises. After completing all the formalities, they pass on the management to their owners or shareholders and then move to another new venture. B. Financial promoters. These promoters have the financial capacity and look forward to opportunities for new investments. C. Technical promoters. These promoters are technical experts in different fields. They make use of their specialized knowledge, experience, and training in promoting new business. D. Entrepreneurial promoters. They are the people who conceive new idea of business, take necessary steps to set up the business unit to give it a shape and ultimately control and manage it. E. Specialized institutions. There are certain financial institutions which provide financial assistance and guidance in launching new venture and often collaborate with new entrepreneurs to promote new business. F. Government. Both central and state governments also act as promoters in most cases where the new business is floated either in public sector or joint sector, which involves huge amount of capital and risk. Steps involved in promotion of a company. Following are the steps involved in the stage of promotion. 1. Discovery of a business idea. The first and foremost activity of a promoter is to identify a business opportunity. The opportunity may be in respect of producing a new product or service or making some product available through a different channel. 2. Investigation and verification. After deciding the nature of business, promoters undertake detailed feasibility studies to investigate all aspects of the business. Depending upon the nature of the project, the following feasibility studies may be undertaken with the help of specialists like engineers, chartered accountants, etc. A. Technical feasibility. B. Financial feasibility. C. Economic feasibility. 3. Name approval. Having decided to launch a company, the promoters have to select a name for it and submit an application to the Registrar of Companies of the state for its approval. 4. Fixing up signatories to the Memorandum of Association. Promoters have to decide about the members who will be signing the Memorandum of Association of the proposed company. Usually the people signing Memorandum of Association are also the first directors of the company. 5. Appointment of professionals. Certain professionals such as mercantile bankers, auditors, etc., are appointed by the promoters to assist them in the preparation of necessary documents which are required to be with the Registrar of Companies. 6. Preparation of necessary documents. The promoter takes up steps to prepare certain legal documents which have to be submitted under the law to the Registrar of the Companies for getting the company registered. Those documents are: A. Memorandum of Association. B. Articles of Association. C. Consent of proposed directors. D. Agreement. E. Statutory declaration. F. Payment of fee. Incorporation. A sole proprietorship or partnership firm can be formed to carry out its business even without any registration. But a joint stock company cannot be formed or permitted to run its business without registration. In fact, a company comes into existence only when it is registered with the Registrar of Companies. The promoter has to fill in a name availability form and submit it to the Registrar of Companies along with necessary fees. The name must include the words limited or private limited at the end. Alg. Steps in incorporation of a company. The promoter has to take up the following steps for incorporation. 1. Approval of name. 2. Filing of documents. After getting the name approved, the promoter makes an application to the Registrar of Companies of the state for registration of the company. The application for registration must be accompanied by the following documents. I. Memorandum of Association, MOA. It defines the objectives of the company and incorporation, approval of name, filing of documents and payment of filing and registration fees. It must be duly stamped, signed and witnessed. E. Articles of Association, AOA. It contains the rules and regulations regarding the internal management of the company. It must be properly stamped, duly signed by the signatories to the Memorandum of Association and witnessed. E. Written consent of the proposed directors to act as directors. IV. The notice about the exact address of the registered office of the company. A copy of the name approval letter received from the Registrar of Companies. V. A statutory declaration that all the legal requirements of the Companies Act. 3. Payment of filing and registration fees. Along with the above documents, necessary filing and registration fees at the prescribed rates are also to be paid. When the registrar is satisfied about the completion of formalities for registration, a certificate of incorporation is issued to the company, which signifies the birth of the company. Memorandum of Association, MOA. The Memorandum of Association is the principal document in the formation of a company as it defines the objectives of company. The purpose of memorandum is to enable the shareholders, creditors and those who deal with the company to know its permitted range of activities or operations. It defines the relationship of the company with the outside world. Memorandum of Association is a document that regulates a company's external activities and must be drawn up on the formation of a registered or incorporated company. V. Clauses of Memorandum of Association. The Memorandum of Association contains different clauses. A. Name clause. This clause contains the name of the company with which the company will be known, which has already been approved by the Registrar of Companies. B. Situation clause. This clause contains the name of the state in which the registered office of the company is proposed to be situated. The exact address of the company's registered office may be communicated within 30 days of its incorporation to the Registrar of Companies. C. Object clause. It defines the purpose for which the company is formed. A company can undertake only those activities which are mentioned in the object clause of its memorandum. D. Liability clause. It contains financial limit up to which the shareholders are liable to pay off to the outsiders on the event of the company being dissolved or closed down. E. Capital clause. This clause specifies the maximum capital which the company will be authorized to raise through issue of shares. The company cannot issue shares capital in excess of the amount mentioned in the clause. F. Subscription clause. It contains the name and address of at least 7 members in case of public company and 2 members in case of a private company, who agree to associate in undertaking registered as a company. Articles of Association, AOA. The Articles of Association of a company contains the various rules and regulations for the day-to-day management of the company. Article of Association is a document that specifies the regulations for a company's operations. Contents of Articles of Association. 1. Share capital, rights of shareholders. 2. Lien of shares. 3. Calls on shares. 4. Transfer of shares. 5. Transmission of shares. 6. Forfeiture of shares. 7. Conversion of shares into stock. 8. General meetings and proceeding thereof. 9. Directors, their appointment, remuneration, qualification, powers. 10. Dividend and reserves. 11. Accounts, audit and borrowing powers. 12. Capitalization of profits. Rules and regulations of Articles of Association. Article of Association of a company contains rules and regulations with regard to following. A. Preliminary contracts. B. Use and custody of common seal. C. Allotment, sales and lien of shares. D. Transfer, transmission and forfeiture of shares. E. Issue of share certificates and share warrants. F. Conversion of shares into stock. G. Voting rights and proxies of members. H. Qualification, appointment, remuneration and the power of directors. I. Borrowing powers and methods of raising loans. J. Payment of dividend and creation of reserves, accounts and Articles of Association. Basis. Memorandum of Association. Ooted and winding up. Meaning. It is the fundamental document which lays it is the subordinate document which provides rules and regulations for the internal working of the company. Articles of Association. Down the objectives of the company. Area of relationship status. It defines the relationship between the company and outsiders. It is the fundamental document of the company. Purpose. It is to define the limits or scope of the company's activities. Alteration of Memorandum of Association. Ease in. Alteration. Difference between Memorandum of Association and B-College. Is complicated. Obligation. Every company has to prepare the Memorandum of Association. Contents. It contains 6 clauses such as name, situation, object, capital, liability and association clause. It defines the relationship between the company and its shareholders, directors. It is the subordinate document to Memorandum of Association. It is to provide directions for the internal management of the company. It is convenient to alter Articles of Association. A public company limited by shares need not to prepare its articles because they can adopt Table A of the Companies Act. It contains rules and regulations regarding internal management of the company, such rules regarding meetings, shareholders, etc. Corporate Administration. Certificate of Incorporation. Certificate of Incorporation is the legal document which makes the company formation valid or brings the company into existence. This mainly includes the following. 1. The name of the corporation with its abbreviation. 2. A statement of business purpose. 3. The corporation's registered office address and name of registered agent for the address. 4. Number of shares of stock which are authorized to be issued. 5. The name and address of the corporations incorporated. Subscription stage. Raising capital or subscription of capital. Final prospectus is printed after the deal has been made effective and can be offered for sale. After the company is incorporated, the next stage is to raise the necessary capital. In case of a private limited company, funds are raised from the members or through arrangements from banks and other sources. In case of public limited company, the share capital has to be raised from the public. This involves the following. Arjuna Didig. A. Preparation of a draft prospectus and get it inspected. B. Filing a copy of the prospectus with the Registrar of Companies. C. Issue of prospectus to the public by notifying the newspaper and inviting public to apply for shares. D. If the minimum subscription has eaved, shares should be allotted to the applicants as per SEBI guidelines. E. Listing of shares in a recon stock exchange so that shares can be traded. Prospectus. After getting the certificate of incorporation or registration, public limited company invites the public to subscribe to its shares. This is done by issuing a document called prospectus. There are two types of prospectus, preliminary and final. Preliminary prospectus is the first offering document provided by a securities issuer and includes most of the details of the business and transactions. Final prospectus is printed after the deal has been made effective and can be offered for sale. Corporate administration. Definition of prospectus. Under the Companies Act, a prospectus has been defined as any document described or issued as a prospectus and includes any notice, circular, advertisement or other document inviting deposits from the public or inviting offers from the public for the subscription or purchase of shares or debentures of a company. Objectives of prospectus. 1. It informs the company about the formation of a new company. 2. It serves as written evidence about the terms and conditions of issue of shares or debentures. 3. It induces the investors to invest in the shares and debentures of the company. 4. It describes the nature, extent and future prospectus of the company. 5. It maintains all authentic records on the issue of shares and debentures. Contents of prospectus. 1. The main objectives of the company, the name and address of the signatories of the Memorandum of Association and the number of shares held by them. 2. The name, address and occupation of directors and managing directors. 3. The number and classes of shares and debentures issued. 4. The qualification shares of directors and the interest of directors for the promotion of company. 5. The name and address of the vendor, amount paid or to be paid, property acquired by the company and the 6. Particulars about directors, secretaries and the treasurers and their remuneration. 7. The amount of minimum subscription. 8. Name and address of auditors, bankers and solicitors of the company. 9. Time and place where copies of balance sheet, profit and loss account and auditor's report may be inspected. Statements in lieu of prospectus. It is a document which is delivered by a company having share capital to the registrar for registration at least 3 days before the first allotment of shares or debentures under the following conditions. 1. Where a company does not issue prospectus, or 2. Where a company has issued a prospectus but has not proceeded to allot any of its shares offered to public for subscription. Statement in lieu of prospectus is to be signed by every person who is named therein as a director or a proposed director of a company. A copy of this statement must be filed with registrar within prescribed time. This provision does not apply to private company. D. Corporate administration. Contents of statement in lieu of prospectus. 1. The name of the company. 2. The nominal share capital of the company divided into number of ordinary shares and par value per share. 3. Description of the business to be undertaken and its prospects. 4. Names, address, description and occupation of the proposed or appointed directors, chief executive, managing agent and secretary of the company. 5. Provisions regarding the appointment and remuneration of the above officers. 6. Voting rights in the meetings of the company. 7. Numbers and the amount of shares and debentures agreed to be issued. Galanum 8. Names, occupation and addresses of vendors of property purchased or proposed to be purchased by the company. Summa following are the statements in lieu of prospectus. 9. Amount payable in cash, shares or debentures, to each vendor of the property. A. Share certificate. It is a document issued under the common seal of the company and it states the extent of the interest of its holder in the company's capital. It indicates the name, address and other particulars of the holder, the number of shares and the amount paid up on shares held by them. B. Share warrant. It is a negotiable instrument which is transferable by mere delivery. It must be stamped according to the market value of the shares. C. Common seal. Every company must have a common seal with its registered name engraved there in legible letters. It acts as the official signature of the company. The seal is required when demanded by the company ordinance or articles of association. D. Dividend. A dividend is that portion of the company's net profit which is distributed among the shareholders in the proportion to the number of shares holding. E. Minimum subscription. It is the minimum amount of shares subscribed by public before the directors can proceed to allotment. The amount of minimum subscription fixed by the memorandum or the articles and named in the prospectus. F. Transmission of shares. It signifies a change in ownership of the securities through the operation of law in case of death or insolvency of members. G. Underwriting. The person who takes risk to purchase a specified number of the shares and debentures of a newly floated company is known as underwriter. Corporate administration. Difference between prospectus and statement in lieu of. Basis. Prospectus. Prospectus. Meaning. It is a document inviting the public to subscribe to the share capital of the company. Purpose. It gives wide publicity to the company and also provides share capital to the company. Filing. It is meant not only for filing with the registrar but also for capital raising registrar. It is normally prepared by big company for fulfilling legal obligations. Prepares. The prospectus gives detailed contents, information about the company, as per the provisions of Companies Act. For whom? It is meant for public at large. Statement in lieu of prospectus. It is a document prepared for filing with the registrar. It is an alternative to the prospectus. It is prepared only for completing the leg formality and not for capital. It is meant only for filing with the. It is normally prepared by small companies just for fulfilling legal obligation. The contents are similar to that of prospectus but form and detailed. Meant for friends and relatives of. Commencement stage. COMMCENCEMENT of BUSSINESS. In case of a public company, a certificate, known as Certificate of Commencement of Business, must be obtained from the Registrar of Companies before starting its operation. For this purpose, it has to file a statement with the following declarations to the Registrar of Companies. 1. That a prospectus has been filed with the Registrar of Companies. 2. That the shares have been allotted up to the amount of the minimum subscription. 3. That the directors have taken up or purchased the minimum number of shares required to qualify them to be director. 4. A statutory declaration by a director or the secretary of the company. The registrar shall examine these documents, and if these are found satisfactory, a certificate of commencement of business will be issued. This certificate is conclusive evidence that the company is legally entitled to do business.